the recent Supreme Court of Nigeria ruling effectively nullifying an administration of criminal justice provision, empowering justices of the appellate courts, adjudicating on matters as a court of first instance, has again brought to question the functionality of an age-old tradition in Nigeria's jurisprudence. In the judgment of the Supreme Court of Nigeria, delivered on May 9, 2020, in the case of UdeJonesUdeogu versus Federal Republic of Nigeria, Section 396, subsection 7 of the Administration of Criminal Justice Act was more or less declared illegal and unconstitutional. The section had empowered an appointed justice of the Court of Appeal to return to the High Court to complete a part-heard criminal case. Now, this morning, we have joining us Femi Falana, SAN, to reflect and to discuss the ruling of the Supreme Court in that particular case and what the implications will possibly be for the delivery of justice in Nigeria. Good morning, Mr. Falana.
Good morning, Mr. Falana.
Thank you for joining us. Yes,
my pleasure.
Let's start with your reaction to the Supreme Court position in the UdeJonesUdeogu case. You had argued that Section 22 of the Supreme Court Act and Section 16 of the Court of Appeal Act allows the appellate courts to sit as courts of first instance. Now, is this not under exceptional circumstances to ensure that there is no miscarriage of justice? Now, will you say that UdeJonesUdeogu's case falls under that category of exceptions? And, you know, there's some clarification that we just need in this regard. Can an appellate court, for example, hear evidence? Because so many persons reading your piece may just need some clarifications.
Yeah, number one, Section 396, Section 7 of the Administration of Criminal Justice Act 2015, to the best of my knowledge, is not as wide as Section 22 of the Supreme Court Act and Section 16 of the Court of Appeal Act. Both sections, I mean, I'm talking of the Supreme Court Act and the Court of Appeal Act, were also made by the National Assembly contrary to the provisions of the Constitution. In other words, Section 233 of the Constitution simply provides that the Supreme Court shall, to the exclusion of any other court, hear appeals from the Court of Appeal, while Section 40 empowers 240 of the same Constitution, empowers the Court of Appeal to hear appeals from a High Court, that is Federal, State, FCT High Court, Sharia Court of Appeal, Customary Court of Appeal. But the National Assembly found that that would not be sufficient. Sections were provided in the enabling acts of both courts to empower them to take over in totality the cases, I mean, the appeals brought before them, and then act as a court of first instance, i.e. High Court. For me, that, and they can take evidence. Whereas Section 396 of Section 7 simply say, go and conclude a part-heard matter.
Let's break this down. So if by law a judge elevated to the Court of Appeal cannot sit over a matter at the High Court, what then happens if the next judge that is sitting over this case is then elevated to the Court of Appeal? Can you help us to highlight the problems with the case going de novo or starting again?
What the problem of a case starting de novo is that it's going to be difficult to get the witnesses. We are talking of a 13-year-old case. This particular case started in 2007. There are others that started in 2008. That is 12 years. If you say go and start all over again to assemble the witnesses, you are going before a new judge to get the evidence together. You know, it's going to be extremely difficult. And that was why, in fact, there was a particular case in which both sides have closed their cases. That is the prosecution and the defense. They have led their witnesses. The court now adjourned the matter for the adoption of written addresses so that the judge could give his judgment. But before the next adjourned date, there was an announcement that the trial judge had been promoted, had been elevated to the Court of Appeal. And that was the end of the matter. So we have to start de novo. 12 years running now, the case hasn't made any progress. So these were the reasons, that led to the amendment of, introduction of that section in the Administration of Criminal Justice Act.
Well, Mr. Falana, let me rephrase the question this way. Are you saying, more or less, that the Supreme Court arrived at its decision in the UdeJonesUdeogu case in error, par incuria? But given the fact that this is now... But given the fact that the position of the Supreme Court in that particular case is now the position of the law at this moment, what do you think could be the implications for other cases that could fall under the same category? Do you see more persons going to court to say, well, this is the position of the law, and our own case should also be treated in the same manner?
With profound respect, I would think that the Supreme Court was not availed the opportunity to consider this section in its entirety. For instance, if the attention of the court had been drawn to Section 22 of the Supreme Court Act or Section 16 of the Court of Appeal Act, that not only allowed them to continue both appellate courts to continue cases pending in the lower court, but to take over and take them as high courts, I'm sure the court will have had a different thinking. Secondly, the court challenged the fiat given by the President of the Court of Appeal to the Justice Mohammed Idris to go down to the Federal Court to conclude the case. I've also asked the question, where it's not in the Constitution that the Chief Justice can give a fiat to a judge to go and sit over a judicial or administrative commission of inquiry set up by a state governor, because the decisions or the recommendations of the commission of inquiry, are lower in the hierarchy. I mean, if you look at the recommendations, what I mean is that once there is a white paper and you want to challenge any provision of the white paper, you have to go to the High Court. Notwithstanding the fact that the commission was headed by Supreme Court Justice, as far as our law is concerned, that commission of inquiry is an inferior tribunal, inferior to the High Court. Secondly, our Chief Justice also gives fiats to judges to go and serve outside the country. Again, when you look at the Constitution, from Section 1 to Section 320, there's no provision for posting a judge outside Nigeria. And so that is why we have to look at this judgment in all its ramifications and the implication for the judicial system. For instance, I have confirmed that over 60 cases are going to be affected. In other words, whereas the President of the Court of Appeal had given fiats to judges to conclude over 60 cases, we are now going to have a situation whereby those cases will have to start de novo. It is very expensive for any state. And this judgment for me would have been okay if anybody has shown a miscarriage of justice. But in this case, the appellant and his co-defendant asked for the fiat. Please give them a fiat to conclude our case, because they couldn't allow the criminal case to hang over their heads like a sword of Damocles indefinitely. Now, if you are now going to ask a court to set aside a judgment in a criminal case, you have to show primarily that there was a miscarriage of justice. There was none in this case. And that is why some lawyers have described this case, this judgment, as a technical escape for, the two people involved.
Mr. Falana, thank you for expressing your views in that regard. Let me ask you something else. Now, some critics of the judgments have also brought up a question or an argument saying that, to be honest with you, UdeJonesUdeogu wasn't the applicant. It was actually his co-defendants, as we know, UdeJonesUdeogu, and therefore this ruling does not apply to him. How do you respond to that?
Well, technically speaking, it does apply to him because it's going to take advantage of it. But it cannot be a basis, the judgment cannot be a basis to get him out of Kuje custody, prison custody. He now has to use the judgment to go down to the Court of Appeal, where he has his own appeal pending, you know, by letting the court know on the doctrine of stare decisis that, oh, a higher court has taken a decision, that is the Supreme Court, which is binding on all authorities and persons in Nigeria. Therefore, on the basis of this judgment, allow my appeal and let me go home. That's what is going to happen in this case.
Well, Mr. Falana, Kenneth Ikone, SAN, I'd argue that, look, what the Supreme Court has done is just to rely on technicality rather than attempting a purposive and more liberal interpretation of Section 396 subsection 7 of the Criminal Justice Administration of Criminal Justice Act, which, in his view, was introduced to correct, to correct a certain mischief, the non-conclusion of cases. But now, with what we have before us, what will you recommend? Will you recommend an amendment of Section 290 of the 1999 Constitution to accommodate what is provided for in Section 396 subsection 7 of the Administration of Criminal Justice Act?
I fully agree with the learned senior advocate of Nigeria and that our judges will have to look at the mischief that laws are meant to cure and then do justice in every given case. But my own worry, and I've expressed this publicly, when it comes to the rich, the bourgeoisie, the law is rather bent to accommodate them. And that is why our courts resort to technicalities, which is not very good because we now have a situation where we are establishing two criminal justice systems, one for the rich and one for the poor, in a country where there are no resources to prosecute cases indefinitely. You cannot afford to resort to technicalities. In this particular case, this is the second time these two cases have gone to the Supreme Court. The Supreme Court has held again, go back and start all over again. So we're expecting that the judgment will go back to the Supreme Court a third time. No country does that in the world. And that is why we have to move with the rest of the civilized community. On this one, there are two ways of going about it. I do hope there are other cases pending in the Supreme Court. So the court can take advantage of some of the comments and views being expressed to have a review of that judgment because, as I said earlier, the attention of the court was not drawn to its own powers to sit as a high court when taking certain appeals, which was never contemplated by the Constitution. Secondly, the judgment has affected Nigerian judges who may be asked to go and serve outside the country. My fear now, because I have appeared before some of our judges outside the country, and they are doing marvelously well. I mean, the late Justice Akinola Aguda was a fine Chief Justice of Botswana. The late Justice Udo Udoma was a fine Chief Justice of Uganda. The Honorable Justice Akomade Agim of the Court of Appeal was a Chief Justice of the Gambia and Swaziland. Now he's on his way to the Supreme Court of Nigeria. Justice Emmanuel Ayola was a Chief Justice of the Gambia. Even my Lord, who presided over this case, the Honorable Justice Bode Rosevivo, was a member of the Supreme Court of the Gambia for 2 years before he was elevated to the Supreme Court of Nigeria. Now, what happens to those judges? I mean, what happens to Nigerian judges that are now seconded to other countries? What happens? Anybody can now challenge their jurisdiction in those countries on the ground that there is no provision in the Constitution of Nigeria that allows the Chief Justice to second you to other countries. So, for me, we need to review this judgment. Second, I mean, the other is to go to the National Assembly and ask that this provision be entrenched in the Constitution. But you can't go to the National Assembly all the time to amend the Constitution. because it's not a constitution of purposeful interpretation, of our laws, and not this constructionist, rather restrictive approach. It doesn't help the country. It doesn't help the cause of justice. It does not even help accused persons or defend them in criminal cases.
Mr. Falana, sorry, once again, we had a slight technical glitch towards the end there, but let me take you up on something that you can't always go and amend the Constitution based on certain things. Earlier on in the week, we were joined on the show by Senior Advocate of Nigeria, Mike Ozekome, and we spoke to him about virtual proceedings or virtual sittings that are currently happening. And he said that what he thinks really and truly is that we need to review the Constitution to give legal backing to virtual proceedings as it contradicts Section 36 of the Constitution. What is your take on virtual sittings?
Because of the coronavirus pandemic, the whole world has moved away from the regular sittings of court. And apart from Nigeria, I've never heard this argument anywhere, whether in the United States of America, India, United Kingdom, or whatever. It's only in Nigeria where people are saying, go and amend the Constitution again. If you look at Section 36 of the Constitution that guarantees the right of fair hearing, there are provisos there, which my colleagues are not looking at. Number one, if you are handling a case that has to do with a child under 18 years, the courts can sit in camera. Also, a minister in the government or a commissioner in a state can inform the court for certain reasons these cases should not be heard in the open. Again, the court will allow it once you can convince the court. In this case, I have suggested what should be done is for the Minister of Justice and the Attorney General to write to the federal courts, while the state attorneys general should also write to the heads of the courts, state courts, that by virtue of Section 36, subsection 4(2) of the Constitution, cases should not be heard in the open, as was the case in the past because of the COVID-19 pandemic. And that will take care of the fears being expressed. But again, we are being asked to go to the National Assembly, go and start all over the process of amending the Constitution, which is going to take months, because apart from the National Assembly, any amendment of the Constitution will also have to go to the 36 state houses of assembly, unless the position of the National Assembly is supported by at least 24 houses of assembly. The amendment will not scale through. So again, I think we're getting unnecessarily technical. The Constitution has already taken advantage of, envisage this kind of situation.
No, on this question, I would like to draw your attention to subsections 3 and 4 of Section 36. The argument, in another regard, is that the Constitution makes it very clear in those two subsections that criminal matters in particular must be heard in public. Subsection 3 also talks about, hearings in public. Now, will you consider the resort to technology, remote hearings in both criminal and civil matters? Will you consider that consistent with Section 36? This is the concern.
Again, I am saying there is a proviso to Section 36. If you go to 34A and B, A says, if the matter has to do with a child under 18, the court will sit in camera. The court will not sit in the open. B says, if the minister, any minister in the government, any commissioner in a state can convince a court that we do not need to sit in the open, that the court will not sit in the open. The court will sit in camera. So the Constitution had already envisaged a situation of this nature. And I have handled cases where the court has held that because of the nature of the evidence, we cannot have evidence in the open. And we have all agreed, my lord, in the interest of the court, in the interest of the lawyers, in the interest of the defendants, let us sit in camera. It's allowed in the interest of peace, in the interest of defense, in the interest of health, and in the interest of the child. You can sit in camera. It's allowed by our law. However, in this particular instance, like this program, once, like in Zoom, most of our courts are going to engage in Zoom hearing proceedings by Zoom or Skype or WebDay. What stops any member of the public who is interested in the case from being given access to the court? And that way, again, will take care of public hearing. That's why I do not agree with my colleagues that virtual hearing cannot meet the provisions of Section 36, subsection 3 and 4.
Very true, Mr. Falana. To be honest with you, on Zoom and other applications, you can have numbers of people joining in if that's the case. So very well understood. Let me bring you up on something else recently that's also happening in River State, the demolishing of 2 hotels that we saw going on. The governor of River State, Nyesom Wike, claims that he acted on an executive order that he had signed, giving him the rights to enforce rules with regards to coronavirus. What is your take on what happened, and how do you think that those who are affected by this should respond?
There is no executive order issued by either the president or the governor of a state in Nigeria that can justify the demolition of a house of a citizen without a trial. Section 43 of the Constitution has guaranteed the right of every Nigerian to own and acquire property in the country. If the government is going to use the property for public purpose, maybe for a school or a hospital or whatever, you must pay a fair and just compensation. Therefore, the action of the governor cannot be justified in any democratic society. And I can tell you, we have not less than 10 cases where our courts have found that you cannot demolish the house of a citizen without due process. In this particular case, the governor is the lawmaker. He made the regulations. The governor is the enforcer of the law. He didn't ask the police to arrest anybody. The governor then turned himself into a court where he became the accuser, the prosecutor, the witness, and the judge, all at the same time, as if those transgressions were not enough. The governor also became the executioner of the judgment. Those acts are totally alien to a democratic society. And that is why all those who are affected will have to go to court to seek legal redress, because the action cannot be justified on that one.
Mr. Falana, if you can hold your thoughts for just a minute, let's go on a very quick commercial break. And when we are back, the morning show and this conversation continues. Stay with us. Welcome back. You're still watching the morning show here on Arise News, and Senior Advocate of Nigeria, Mr. Femi Falana, is still here with us on the show, looking into a number of issues. Thank you for staying with us, Mr. Falana. Before we went on a break, you were commenting on the demolishing of 2 buildings in River State and your take on that. Would you like to conclude your thoughts?
Well, incidentally, this is not the first time the human community has challenged the legal demolition of properties in River State. I remember in 2002, in the case of Serak and Nigeria, the federal government was dragged to the Human and People's Rights in Banjul, the Gambia, for colluding with Shell Petroleum Corporation to demolish the properties of the Ogoni people. And of course, the commission made it abundantly clear that the government of Nigeria violated Article 7, right to fair hearing, and Article 14, right to property, entrenched in the African Charter on Human and People's Rights. I also recall in 2010, Governor Rotimi Amechi wanted to demolish a waterfront in River State. The SERAP took the matter up in the ECOWAS court. I handled the case. Again, the court made it clear that the decision of the government to violently attack the protest, against the planned demolition by the people living in the waterfront, it cannot be justified under the African Charter. And the court also made it clear that the government has a responsibility towards the provision of housing for citizens, talk less of demolishing the ones that the citizens have built, and that therefore there has to be a procedure. I also handled the case, that's for Rivers State. I handled the case of the Pape people in Abuja, where the federal government, FCT territory, administration wanted to demolish the entire, land on the ground that the people were living there illegally. The court, the FCTI court made it clear in that judgment that we're not saying the government cannot demolish a property, find one thing, but there must be a procedure. In the case of Rivers State, the governor is saying that his executive order has been violated. Again, the people alleged to have violated the executive order will have to be taken to a court, constituted in a manner pursuant to Section 36(1) that will guarantee the independence, the autonomy of the court, so that the court and the impartiality of the court, so that the court can hear the case. The Attorney General of Rivers State will have been required to charge the hoteliers to court. And if the court finds them guilty, the court will make an order in line with the regulations of the executive order. Even if the court orders a demolition, again, it's not the business of the governor to supervise the demolition. That will be done by officials of the court in the bailiff section, the bailiff department of the court. But there's no way a governor can take the law into his hands and decide to say, oh, this citizen has disobeyed my order. I am going to demolish his house. Unfortunately, the case reminds me of the case of Amakiri and in Rivers State in those days under the Gowon regime, where a governor felt that he was embarrassed on the day of his birthday by journalists who had written about, lack of facilities for education in that state. And the governor, a military governor, Dete Spiff, who is a traditional ruler now, got soldiers to abduct the journalist, Amakere. He was detained. His head was shaved to the skull. He was brutalized. The court said, under the military, that was primitive. No ruler, no leader is allowed to take the law into his hands, and damages were awarded against the conduct of the governor. In the case of Odi, when the Obasanjo regime demolished Odi, Zakibiam, and I think there was another one, I think under the Yaradua regime, when Baramotu was attacked, I am aware that in 3 separate judgments of the Federal High Court, the total sum of 166 billion naira was awarded against the government of Nigeria. Part of the money has been paid, and I know efforts are being made by those who won the cases to have the compensation paid. So there is no way you can justify the illegal demolition of houses in Nigeria.
Mr. Falana, in the face of COVID-19, the National Assembly of Nigeria has been trying to come up with what they call an infectious diseases bill, which is supposed to be a repeal and an amendment of the Quarantine Act, more or less. Now, again, you have some other Nigerians saying that this is premature in the middle of a pandemic. This is not the right time to come up with that bill. And there are others who argue that that bill is an imitation of a similar bill 49 years ago in Singapore, which had even been updated by Singapore. And that there are provisions in that particular bill that are draconian, that erode fundamental human rights. But it looks like the National Assembly is determined to pass that bill, even accelerate it. Only yesterday, Nigeria Governors Forum was also saying suspend the bill and allow for more discussion and more inputs. What would be your advice to the National Assembly on the question of this infectious diseases bill?
My advice to the National Assembly is that the bill be dropped in its entirety because it is superfluous, illegal, and unconstitutional. The superfluity of it arises from the fact that the National Assembly has conveniently forgotten that there was a law enacted in 2018. We are no longer dealing with the 1926 Colonial Quarantine Act. The Nigerian Center for Disease Control Act of 2018 has taken cognizance of the fears of the National Assembly. So that's what we should be dealing with, not the Quarantine Act. But the beauty of the Quarantine Act is that it empowers the president and the governors to deal with infectious diseases. The only area of that law that will require an amendment is the penalty for violating the regulations made pursuant to the Act. You are required to pay only 200 naira. So we definitely need to adjust that and make provisions for higher penalties. But on a very serious note, the fact that a law empowers the president to take charge of a situation gives the opportunity for the president to mobilize resources, as it is the case now, of governors to mobilize resources and also adopt measures that will take care of local peculiarities. But what the National Assembly is trying to do, the House of Reps, in the Infectious bill, is to divest the president and the governors of the powers which they currently enjoy and confer all the powers on an unelected person, that is the Director General of the NCDC. That cannot be allowed. More so that Singaporean law is backward. It's no longer in tune with current reality, which has been copied and pasted by the House of Reps. And I can tell you, the law has not examined, the law has overlooked the provisions of our Constitution and other laws. For instance, the law says, almost like the River State, akin to the River State situation, that if the DG of the NCDC feel that there is suspects that there is an infectious disease somewhere, he can acquire your house without going through the procedure permitted by law. He also can order your arrest without any warrant. He can order vaccination without your consent, and so on and so forth. Again, these are strange provisions that cannot be accommodated under our law. Our courts have handled cases in this regard. So what I would rather enjoin the National Assembly to do is to abandon this dangerous path, look at the provisions of the NCDC Act 2018, look at the provisions of the National Health Act 2014, look at the provisions of the National Health Insurance Act of 2014, and see how we can update these laws to make provision for compulsory health insurance for every Nigerian in the private and public sector, and ensure that the government increases allocation to health on an annual basis. For me, these are the challenges before the National Assembly, and not going to destroy rights that have been recognized by the Constitution and our courts.
Mr. Falana, certainly there are a lot of worries with regards to the Control of Infectious Diseases Bill. We have just a couple minutes left. It would be great to get your views on the recent appointment of Professor Agboola Ibrahim Gambari as the Chief of Staff to the President.
What
well,
the President has
Mr.
made...
Falana, before you answer, if I may add to that, considering the age of the President and also the age of the Chief of Staff, do you think that these two gentlemen can effectively complement each other? Because many Nigerians have said, I mean, two geriatrics, President and Chief of Staff.
Well, I do not believe in what we might call gerontocracy, but at the same time, we must appreciate that wisdom has nothing to do with age, You have young, very reactionary young people who should not even be allowed to move near the seat of power. You also have some old men who may also be able to run a country very well, although there are some old men, that are trying to cause problems all over the world. But again, on a very serious note, with respect to Professor Agbola Gambari, the president has made his choice. Nigerians can only react by ensuring that the country is run properly. And if you must know, we must not elevate the office of the Chief of Staff beyond the provisions of the Constitution, as was our recent experience. We vote for leaders in this country, and we must never empower anybody who has not been elected to ride short over all of us. I mean, in the protocol of the government, the president comes first, the vice president, the chief justice of Nigeria, ministers of the government. So the office of the chief of staff is unknown to the Constitution. But with respect to the choice of the president, again, as I said, the president has made his choice from the CV of Professor Agbola Gambari. He's eminently qualified. The choice is now before Nigerians to ensure that this country is run properly.
Well, Mr. Falana, on that note, we have to thank you very much for joining us this morning on the morning show.
Thank you for joining us.
This has been quite an exciting conversation, and I'm sure our viewers, will also be pleased.
Yes.
Thank you very much.